Hi everybody, I'm AJ Singh, CPA at GNS Accountancy. Today I want to talk about misclassification issues. Misclassifying employees as independent contractors. As many of you know, AB5 was passed in California and is effective as of January 1st, 2020. We've done previous podcasts on AB5, so please click on the link that pops up on your screen to take a look at it. The basics of AB5 are if the independent contractor is in the same line of work as the employer, then they are employees for AB5 purposes. There's an ABC test. The ABC test basically assumes that the independent contractor is an employee unless they can pass the 3 tests. Many states use the ABC test, and states like New York and New Jersey have bills pending in the legislatures. AB5 doesn't just affect employers in California, it can also affect employers out of state too. Employers out of state are more likely not to hire independent contractors in California because those independent contractors are subject to the AB5 rules. So the non-California company has to apply the ABC test to those freelancers or independent contractors that it hires from California. So you may find more hesitancy from those out-of-state employers when they're trying to hire independent contractors from California. Misclassification issues were there before AB5 was put into effect. If the independent contractor was working under the supervision of the employer, i.e. they're using their tools, they're using their equipment, they were independent contractors even before AB5. Many companies or clients come to me and they say, well, AB5 has now passed, do I need to now reclassify my independent contractors as employees? And my answer is always, AB5 has not changed anything. Your independent contractors were always employees even before AB5. What AB5 does is it pulls in another class of independent contractor that are truly independent contractor, but they're employees now under the ABC test because they're in the same line of work as the employer. How can you transition from misclassifying your independent contractors and switching them over to being employees correctly, especially in a situation where making the transition could cause financial hardship for the company? Now, my recommendation is to do this gradually, and this is not legal advice, so please consult your attorney on matters regarding law, but you want to minimize your potential tax liability. If the California EDD, which is the Employment Development Department, comes to audit you now, or the IRS comes in, they will reclassify all the wages, most likely in the last 3 years, as payroll wages, and that would result in high tax liabilities, penalties, and interest. So the more contractors that you can now transition as employees, the more you're reducing that potential liability. Your payroll tax liabilities may be around 10% of the wages paid. The employer expense for payroll taxes, including IRS and the EDD, are about 10% of the payments made to your contractor. The biggest expense will be workers' comp insurance, depending on what class of employee you have. More riskier jobs will be higher insurance. And you will also have to have some risk management procedures to minimize any claims on the workers' comp insurance policy. And also the workers' comp insurance expense should go down over time as you have minimal claims, hopefully no claims at all. There's also self-insurance options which can be cheaper, but you have to talk to an insurance specialist about self-insurance or captive insurance policies. Now, if you do get audited, the IRS has certain programs for relief, such as the Section 530 Safe Harbor. To qualify for the Section 530 Safe Harbor, the employer must never have treated the independent contractors as employees. If the California EDD audits you the first time, then they can be more lenient. If you have any questions regarding misclassification issues, or you have a pending audit with a state or federal agency, please reach out to me. I'm AJ Singh, CPA from GNS. I look forward to speaking to you soon.